All right, thanks, Kevin, and thanks, Mario. Great knowledge, great sharing here. Hi, everyone. I am the other MEA attorney. You don't have your wonderful Amy today. I've gotten to talk with her though and find out what should we share today. So no sort of additional guidance from the Department of Labor, but we're going to revisit and talk about some other portions of the guidance that Amy talked about last week, the FAQs that the Department of Labor issued, the COVID-19 FAQs. So we're going to talk about a new one there and talk about some things to just be keeping in mind, again, as we continue to navigate these things. And Jane, we're lucky to have Jane here. Tell me, do the questions continue to come in from members about these topics?
Yes, absolutely, all the time. So, and keep them coming.
Yeah, keep them coming. And we love being here to help guide you through some of this change in this legal and compliance space, because as Mario was saying, the changes are across the board, including in this area, right? So last week, Amy mentioned this April 26th, 2021 executive order about worker organizing and empowerment that came out of the Biden administration that Biden signed into effect on April 26th. Why are we talking about this, right? So this executive order established a White House task force that is aimed at trying to get the federal government to become sort of a model employer with respect to worker organizing. So to come up with suggestions, recommendations for helping employees of the federal government to collectively bargain with the federal government. Now, why would they do this, right? Well, yes, Biden and Harris are champions of unions, but also, and you may recall this from a couple of weeks ago, there is a piece of legislation pending, a huge piece of legislation that's been passed by the House of Representatives, and that's sitting before the Senate. And that's the PRO Act. I have it in my head as the PRO Act. That's how I refer to it, but I think it's protecting workers and their rights to organize, basically, is the law. Well, the thought out there, right? Experts think that the actions by this task force will likely be a model for some of the policies and procedures that make their way into that legislation. As it's sitting there now, so the PRO Act that we talked about a couple weeks ago, as it's sitting there now, it will likely get modified so that it can pass the Senate, or it will have to be if it's going to be passed. And many people think the changes to that legislation that will happen will be drawn from the work of this task force in their effort to become this sort of model employer in this space. So that's why it's important for all of us to keep an eye on this task force. And MEA, we're going to let you know as important developments arise, if they have any significant recommendations coming out of this task force. We're going to keep you posted just so that you're thinking about it and aware of what may make its way into that legislation. But suffice it to say, the White House is very in favor of worker organizing and is focused on it and is really approaching this strategically. And so we've got to keep ourselves up to date on that. Again, the Department of Labor has issued some FAQs around wage and hour issues in COVID-19, right? Why is that important? They are putting it in plain and simple terms, right? They want workers to understand, here are some of the issues that could pop up when it comes to wages and COVID-19. Here is the information you need to see if your employer is paying you properly. So again, important for employers to keep aware of it so we can stay compliant and keep those employees happy. Right. Some of the one of the FAQs that Amy reviewed last week was about temperature checks and whether to pay for temperature time spent doing temperature checks. The FAQ answer that the Department of Labor shared is you got to pay for it if it's essential to the person doing their job, right? If it's necessary for them to get their job done, this screening, and you've got to pay for it if it happens during work time, like after the person's clocked in. I'd say, and this is pretty consistent with what Amy shared last week, err on the side of paying folks for this little bit of time. If you're in doubt, like, is this really part of their job or not? I would err on the side of paying them for that bit of time if you want to ensure compliance. Part of that's important because there are a couple ways that wage and hour laws get enforced. One is the Department of Labor could investigate a complaint from a sort of unhappy or disgruntled worker. But there's also a whole sort of legal practice that plaintiffs' attorneys have built over this issue of small increments of time that haven't been paid. And they kind of gather together large groups of employees into a class action to make that monetarily feasible for them, because it's something that's easy for employers to miss or overlook, but when gathered together in mass is very profitable for a plaintiff's firm. So if you're in doubt, err on the side of pain. Jane, I can just talk and talk. So I like to pause and say, Jane, any thoughts or insights that you'd like to share?
Not related to this. No, keep going.
All right. It's like wind up the Energizer Bunny and then send it off, I'm like, had my coffee. Okay, another FAQ. This is a new FAQ that we're covering this week from this same guidance from the Department of Labor. They issued some COVID-19 guidance around nursing breaks, right? For nursing mothers, lactation breaks, some companies call them. Interesting, because I've had a couple questions about this recently around, look, we're getting ready to return to the workspace because of spacing. We're not sure that we can have one designated room for nursing mothers anymore, or we never had one, but we have an employee who's asking about it and we think it's not really feasible because of the spacing requirements of COVID-19. You still have to do it, is basically what the Department of Labor is saying. There's no break from the requirement to provide nursing breaks in a private area that is not a bathroom. Okay, so here on this slide, I'm providing you with sort of a little refresher on the requirements here, which this is part of the FAQ answer from the Department of Labor. Employers who are covered by federal wage and hour law, which is most employers, must provide reasonable break times as needed to an employee within the year after the birth of a child that they are breastfeeding. And do those breaks have to be paid? Not necessarily. We'll see that on the next page, but the time has to be allowed. And the employer has to provide a private space that's shielded from view that is not a restroom for those purposes. Jane, what happens if they don't have a separate room that is always available for lactation breaks?
That's a great question. I mean, I can only speak from experience where in one of company I worked in, I had a private office that became the lactation room when someone needed it.
And they would just email you ahead of time, am I correct?
Yeah, and I vacate for the amount of time they needed, and it worked.
All right, and that's perfectly compliant. So if you're in that situation where you can't have a full-time dedicated room, there are workarounds, right? But you have to be able to provide a non-bathroom area for someone to do that as needed. Also, we recommend a lock on the door, there are other measures. If you have any questions about is our area compliant, is our policy on this compliant, feel free to reach out to Hotline, and Hotline, Jane and Legal Services will be able to support you in figuring that out. Here were two more pieces from that same FAQ from the Department of Labor, just again emphasizing that these are required breaks. There is an exception that the Department of Labor noted for this particular circumstance, right? Employers with fewer than 50 employees who can show that it's an undue hardship to provide this. My guess is that most often it's going to be very difficult to prove that it would be an undue hardship, but if you think that you might fall into that category, again, reach out to MEA Hotline or Legal Services and get some tailored advice to see, is that sort of a viable argument, and what steps you can take to sort of preserve the information you might need to show that undue hardship. If you're wondering about whether you have to pay for breaks, not always. The guarantee for nursing mothers is unpaid time, but if an employee chooses to use time that otherwise would be paid, like let's say you provide paid lunch breaks, right? And instead they're using that time for nursing breaks, then they also receive pay for that time period. Amy shared with you last week, the EEOC has released its 2020 statistics. She shared some of these numbers with you. I noticed, she said, yes, there's been a downward trend. I want to caution people, don't get overly comfortable with thinking, oh, there's a downward trend in discrimination and harassment claims. Because they're absolutely out there. And I suspect just from talking with members that there are some issues bubbling up that are sort of more unprecedented, that haven't been addressed in the past. And I think there's a sort of a friendly apparatus in place with the current administration for those types of claims. So this is not a time to sort of drop your guard on these things. The Biden administration has made very clear that they are asking the agencies of the federal government to put their full effort, as much authority as they have, into enforcing LGBTQ anti-discrimination provisions and anti-harassment provisions, just as an example, right? And so those are claims that previously have not gotten as much attention and as much focus from enforcement agencies that are going to be getting a fresh look in a very changed social environment from, say, 10 years ago, right? So this is not a time, again, to let your guard down. And by that, I mean, your guard in this area is just doing the right thing, right? It's doing what an employer should do to try and make sure that workers can come to work, do their job without being subjected to harassment or discrimination. And you do that by doing the things that Amy sort of reviewed with you last week, making sure you're training everyone, making sure you have a compliant policy. You can get a review of that with MEA membership. So if you haven't submitted that for review, please feel free to. Making sure that you have a compliant reporting procedure. It's got to have multiple channels is one of the big things. It can't be that the only way to report these concerns is to HR, right? There has to be an alternate avenue as well. So that's a big thing that people miss oftentimes. In terms of, I wanted to mention, there was one more thing Amy asked me to mention. There was a study she shared with me by, it's called Limeade organization. They poll employees and share results. And employees evidently are thinking about the same things that Mario was sharing earlier today. But a couple of interesting notes there. Most of the employees responding, over 50%, felt that employers felt that they wanted continued flexibility in their work and the way they do their work as employers are thinking about their policies for transitioning back to the office. And a significant percentage said their employers have not been speaking with them about burnout. And that seemed to be sort of a concern. And that's something to think about, right? As you're approaching this topic of transitioning back to the workplace, don't forget about your good workers, your high potential employees who maybe were operating at burnout levels for a lot of 2021, and that may not be a realistic, or maybe it is with the efficiencies that you're going to be building in with your changes in technology and whatnot. So again, just something to have on your mind, and I'm sure that Amy will delve into that a bit more next week. I also just wanted to mention, because I find it so helpful that, and I know Kevin's mentioned it and Amy's mentioned it, but that MEA's YouTube channel has all of these sort of compliance updates posted to it. So if you're ever wondering about something you may have missed, sort of in case you missed it last week or the week before, we've got our union segment on there. We've got our emergency paid sick leave of 2021 segment on there, and a number of other helpful segments. Anything to add, Jane? I think that's the end of my sharing.
Myself. Oh, no, good.
All right.
Great job. Thank you very much. That was great having you all. So again, we look for seeing everybody next week. Thanks again to Mario as well today. Great session. We'll talk about the healthcare next week. Someone just asked, is anything on Governor Wolf opening businesses? So he has, they have expanded the when you can open. I think we're still waiting for reducing of restrictions around, mask wearing and the like, but that's got to first come from the CDC. And I know there's a lot of discussion right now that they're going to come out with something soon. It all seems to tie to the level of vaccination across the country. So, but I think we mentioned last week, Governor Wolf has expanded. You can come back to the office. And I think as of May 31st, pretty much all the limitations on size and so on and capacity are being eliminated.
Exactly. Yep. Yeah. That's spot on. But for now, we're still doing temperature checks and we're still doing mask wearing inside until we hear more from Governor Wolf.
Yeah. And again, remember, temperature checks can be self-checked with a confirmation to you, so by email or some other way. So.
And just one
All
note,
right.
Philadelphia's release is at 1:00 today. We'll be releasing opening guidance for businesses in Philadelphia.
Yeah. So we'll make sure that we're getting out all that information. And again, join us every week, and whatever's new from the week before, we will always cover on our town halls. So thank you all, and have a great week. Take care.